Hello, everybody, and welcome back to SEC Roundup. I'm Nick Morgan, the co-founder of ICAN, Investor Choice Advocates Network, and the co-host for today's SEC Roundup. Joining me as the other co-host is Mark Hiraide. Mark is a partner with Mitchell Silberberg, and I am proud to say is ICAN's Senior Legal Director and Policy Counsel. Mark, thank you for joining.
Thank you, Nick. Pleasure to be here.
And we're also joined by Dr. Thomas J. Powell, of the Brayhan Group. Tom, thank you for joining. We're going to talk about a matter that you've had ongoing with the SEC for some time. So thank you for coming up.
Nick and Mark, welcome to the team. It's absolutely my pleasure. Thank you. Thanks for the work you're doing.
It's our pleasure as well. And so the issue that we're going to talk about, we have labeled at ICAN Forever Bars, as a sort of colloquial way of describing something that's a pretty serious topic for those people who are affected by it. And that is SEC administrative bars. So these are bars the SEC can impose on people that do a variety of things. Tom, before we get to your specific administrative bar situation and the development that happened this week, maybe Mark can give us a little bit of a backgrounder on administrative bars generally.
Thanks, Nick. The SEC brings many of its civil enforcement actions not in federal court where the defendants have a right to a jury trial, but they also may elect to instead sue in an administrative proceeding before an SEC administrative law judge. Administrative proceedings are remedial. They are not intended to be punitive. And so the remedies in an administrative proceeding must be designed to protect the public interest. Now, before June of last year, the SEC would bring actions charging securities fraud and seek civil monetary penalties in administrative proceedings. But last June, the Supreme Court, with the help of Nick and ICAN, filing a friend of the court brief in a case called SEC v. Jarkizi, held that under the Seventh Amendment, the SEC must bring civil penalty actions for securities fraud in federal court where the defendant is entitled to a jury. Nonetheless, potentially one of the most draconian remedies that is still yet available to the SEC in an administrative proceeding is the industry bar. A bar effectively prohibits a respondent from being employed in the financial industry. And unlike a one-time penalty or fine, which can be paid off, you can imagine the ramifications of a bar for someone who spent their entire career in the industry, or especially for a young person planning a long career in the industry. In addition to barring an individual from employment, the bar may also extend to any activities related to penny stocks, which the SEC defines as stocks $5 or less. And ironically, the penny stock bar is so extensive that it precludes even the respondent from purchasing any penny stock with their own money. Now, bars are indefinite in time, but the Commission rules provide for reapplication upon a showing of public interest. The administrative orders themselves may specify the number of years, usually between 1 to 5, when a barred individual may apply for reinstatement. However, the problem is that the time it takes for the Commission to respond to applications for readmission. Although the Administrative Procedures Act requires the SEC to take action within a reasonable time, and courts have interpreted it to mean months, not years, in practice, in many cases, it may take years before the SEC even responds to an application for readmission. Not only is it fundamentally unfair that the industry bar then effectively becomes a permanent bar, but there are other collateral consequences to a bar that the respondent must suffer. One of those collateral consequences of a bar is that it triggers the bad boy disqualification provisions of Regulation D. Now, since most securities offerings that are not registered public offerings are made under the Regulation D safe harbor exemption for registration, without a waiver by the SEC, the industry bar will preclude one from participating in most capacities in the sales of securities. Another disqualifying bad boy event relevant to this case is a cease and desist order that either charges a violation of the scienter-based anti-fraud provisions of the federal securities laws. Scienter is just the state of mind requirement for fraud, which for civil securities fraud requires a showing of knowledge or reckless disregard for the truth. So the scienter-based securities fraud claim, which triggers the bad boy disqualification event, requires the SEC to prove that the respondent knew of the misstatement or was reckless. In Tom's case, there was no allegation of scienter. Usually, when the SEC does not have evidence to charge knowledge or scienter, it may charge a negligence-based securities fraud, even though the respondent had no knowledge and was not reckless. But the SEC argues should have known about the misstatement or omission. That's the reason that it's only the scienter-based security fraud charges that are subject to a cease and desist that trigger the bad boy disqualification provisions. However, another bad boy disqualifying event is a cease and desist order relating to a registration violation for a failure to register under the securities offering under Section 5 of the Securities Act of 1933. And in Tom's case, the order did include a violation of the registration provisions, which requires no mental state. It does not require scienter, nor even a showing of negligence. So in that sense, it's a strict liability violation. Either you violate it or you do not, which makes it even more urgent that an opportunity for reconsideration be heard by the commission as soon as the bar period is satisfied. I'll turn it now back to Nick and Tom.
Thank you for that. I think the background's necessary to understand that where this comes from. I think, Tom, you'll get into, Mark referred to this as a professional death penalty and talked about some of the collateral impacts that are not in the four corners of the bar order itself. So with that background from Mark, Tom, let's turn to you for a minute. You did settle with the SEC, and part of that settlement was the entry of an administrative order. Part of that administrative order was a bar with the right to reapply after 2 years. But give us the background, maybe just at a high level, of how you got to that bar and what happened since. But before you do that, let me admonish you. As part of the settlement with the SEC, you agreed to neither admit nor deny the truth of the findings in the settlement order. And so I don't want you just steer well clear of the underlying events that gave rise to the order. We're going to talk about what happened really post-order. And I understand that you are the lead petitioner in a legal proceeding called Powell v. SEC that's now pending in the Ninth Circuit Court of Appeals with NCLA. I think that you're counsel in that matter, challenging the SEC's ability to impose neither admit nor deny conditions on settlements on First Amendment and other grounds. So all the more reason for you to just steer clear of the underlying events. But if you would, just give us at a high level sort of the chronology of your interaction with the SEC. And I know you'll have to leave out a ton of detail, but just so we have a sense of it.
Well, we don't want to make the show too long, but first of all, thank you again for that iteration about how the process goes, and it barely even touches the topic at the end of the day. The one that I want to mention on there is the word fraud, which fraud, for most people that are not in the legal profession, they think fraud means intent, and fraud means that you did something really, really bad to steal something, if you really got down to the most simplest layman's foundation on that. However, what we found with dealing with the SEC, there's actually two types of fraud. There's what our attorneys called the little f fraud, which is you did something that was either known, non-scienter, right, or non-known or known. So there's a negative, I guess, approach in that. And so forever, even within our order, so not stating anything that's out of rights, ours was a non-scienter order, right? And
a so-called negligent fraud claim.
It's a negligent fraud, which could be as little as the piece of paper had an error in it and you handed that to someone. And so that is, and you didn't know that there's even an error within the paper, but that is in of itself fraud. Right. So I think that's a really important part, because it says that, oh, you need this to be the requirement. They put a footnote in it and say, but if you did this, then you still should have known or may have known or whatever. So we're going to negate the negation. So it's a double negative, which is great for algebra, right? So you get in there. So starting in 2016, we get after a 35-year career at that point, we get this nice little memo from the SEC saying, hey, we'd like to chat with you about some other issue out there. It takes 4 years, hundreds of thousands of documents that we're not even the named person in it. It ends up being something that they say, as the administration is coming up and the timing is coming up, they said, hey, we'd like to settle this. They prepare the settlement, send it. We look at it and say, this isn't what we talked about. Nonetheless, we get to this point that it's, sign it or it's going to cost tens of millions of dollars more to continue to battle this scenario. So the initial bar was not supposed to be in there. FinCEN was supposed to waive that, and that was part of the agreement within there. So it took another year of conversation within that period that they get down to and said, look, there's been an administration change, and the new SEC chair has forbid us from negotiating any of these non-bars within these settlements. And so that's where the timing came into where this finally got executed in September of 21. That's the bar. That's, we have a whole story behind that. In September, it gets approved by the commission, and we take a 2-year sabbatical from what we think is going to be a 2-year sabbatical. And it turns out not to be really a 2-year sabbatical. So far, it's been coming up on 4 years right now as we're at this scenario from when we've been doing capital. And again, my background comes out of Silicon Valley in the 80s, working in banking, started our first fund in 92. So it is that lifetime scenario where it's been an impact. It's been interesting. Nick and I meet through a series of events and start talking about that at year 2, we will petition to release that bar. He wants to wait a little bit time past that. Plus we're doing the research and send off the letter, I think January 2024. To the SEC, and it was literally crickets. I think you even had to call the office to make sure that they received it. You didn't even get confirmation that they received it, right? And that's at most what they would do. We haven't heard anything. During that time, you take on a case through ICAN that is a similar somewhat case of these are forever bars, and literally it's just to have the SEC respond to the letter. So it's almost like doing a FOIA request. You can put one in, but you may not ever hear anything about the FOIA request. So we're not hearing anything. You're going through that. Consequently, the NCLA understands about my case and says, hey, we'd like to have you join us and bring this case in the Ninth Circuit, which we were happy to do because I do believe that it's unconstitutional. We'll see where that ends up playing out. As that's going through, still crickets about the SEC. And lo and behold, earlier this week, we get an order from the SEC saying, hey, we'd like to review this permanent bar scenario. And that's where it stands today.
That's where we are. So nice recap, Tom. So events at issue were back in 2016, so 9 years ago. Settlement was in 2021. And just to put it in the legalese, with a 2-year bar of certain conduct that you could apply after 2 years to be reinstated. Then in January of last year, 2024, we did file a motion with the SEC to address those bars. And then here we are in April of 2025. And I don't want to understate the significance or the possible significance of what happened this week, but the commission, meaning the currently 3 commissioners, directed the enforcement division to respond to the motion that you filed a year ago.
15 months ago, 16 months ago. Yeah.
Thank you. Yes. So that could be significant. I mean, it could be, but as Mark described it, the potential for these bars to just kind of sit around for a long time is real, and historically has been real. I want to read a quote from then SEC Commissioner Mike Pivavore about the reinstatement process. He issued a dissenting opinion in one of these, and he said, "Based on my experience as commissioner, the reinstatement process, even if successful, can take years to complete after the requisite time period has expired. Moreover, since there is no assurance that a petition for reinstatement will be granted by the commission, the right to reapply for reinstatement can be illusory," was his word. So even if someone settles to something that's a 2-year bar, that doesn't mean that after 2 years go by, you file a motion to be reinstated, it gets granted, and you go about your merry way. So okay, it's been a long time. You have lived for more than 2 years with this bar that you settled to. But some people might be asking themselves, so what? This bar imposed some restrictions on your ability to work in the investment advisor space. The vast majority of the population doesn't work in the investment advisor space. So why is that a big deal? Can you describe, Mark described sort of abstractly what collateral impacts can come from one of these bars, but other than being restricted from acting in certain capacities in the investment advisor space, how is it living under one of these forever bars?
Mark, you want to take the first part of that?
That's yours.
You want me to take that one? Okay.
Yeah. What's it like? What's a real person like?
First, I want to tell you, it's great, the word illusory. I think that the SEC uses that when they attack people or companies about what they've put into documents.
Maybe so.
Right. So that becomes a point where they actually take down a company for their activities, yet they use that within their own activities, which is very interesting. The informed consent of the bar was negligent at best by all parties. So by that, what I mean is it looks like, okay, we're going to get a 2-year bar. I'm going to pay. And by the way, it started out as, hey, this is going to be hundreds of millions of dollars in fines potentially, and it ends up settling for a $75,000 fine, which is public record. So it was, that's like the minimum number that the SEC seems to accept to say these things can go away. So dollar-wise, wasn't a huge impact. Initially, we thought, okay, this won't be a major impact. We've got offshore capital that's being raised. Well, immediately, all companies that I was tied to were cease and desist for any offshore capital raised by other agencies. So that was one of the pieces that ended up happening. And that impacts other investors and other investor projects that are going. That, again, was okay, somewhat maybe we could have anticipated. The next one was, it was a small expense, but it was an expense nonetheless. When we started the negotiation, we said, okay, we'll do a 3-year ICC, an external auditing firm that comes in and says, hey, we're doing everything properly. We agreed to that, right?
And ICC, for those who know, an independent compliance consultant.
Right. So we've got an ICC coming in. Thank you for clarifying that, since acronyms are always the tough things in this business, right? But so we agree to that. Even though we take this now 2-year bar, which means we're not going to be doing any business, we get to have a 3-year ICC audit coming in every 6 months, which was on like clockwork, coming in and saying, okay, well, they're not doing anything, but we still got to pay for it. So that was an interesting part of saying, it kind of seems like it's a juxtaposition of, should have we gotten this or should we have gotten that scenario? The next one that was unanticipated was my trading companies fired me, all of them, like, and for a long time standing relationships with many of these. So get checks in the mail saying we can't run the risk that you're going to do a penny stock trade at this point. Now, my bar said I could do all trading, I just can't do penny stock trading. So, but at that point, because there was that risk, they said, and what that also included was my 401k, my IRAs. All of those accounts were summarily closed, and then you've got to be able to figure out where that goes. One of the other impacts that we absolutely did not expect, I've been a long-time great client of American Express. While employees are out traveling around on our corporate American Express cards, they summarily closed the accounts. And so we've got people stranded out in the fields and figuring out how we do those things. These are minor challenges, but they're real-life challenges that weren't disclosed as possibilities that go on out there. And where that's led to is every time you go to apply for any type of credit or anything, it's like, gosh, is this going to be a challenge? I had to resign from a number of boards that I sat on because we didn't want to have any negative impact onto those. So financial advisory scenarios. And by the way, I was not a registered investment advisor. I was not involved specifically in stock trading as a broker dealer in any of those areas. My understanding is that through the Dodd-Frank rules that they actually were able to even reach into where our business was. Because so we had to give them that right to be able to look at us, but we weren't trading stocks or private enterprises or anything along that line. So the last part that's done is on the good side, my wife would tell you, it caused me to get more curious about this space of law and do an international law degree through Northwestern and see where it does for both impact for internationally as well as domestically, and then do my doctorate research on how this impacts what goes on. So that's led to the positive upsides of it.
Nice of you to see a silver lining in that, Tom.
Yeah.
And I'm happy you got your PhD in law and policy. Frankly, regular people should not have to have a PhD in law and policy to figure out how to interact with the capital market. So the negative collateral impacts are very real, and I think probably not widely understood. So thank you for explaining that.
Nick, if I could just stay in there, what was the most eye-opening and just confusing thing to me is that we're, again, going through school in the 70s and early 80s is we had these civics classes about where everything's fair and the government is this, and you get your day in court and you get a voice and you're innocent until proven guilty. Well, this is a civil matter. And I know your listeners understand that, or viewers understand that, but the general population doesn't understand that. The other impact is the amount of times that I am considered a criminal, even by lawyers that will say, well, you're a criminal because you settled with the SEC. It's like, it's a civil matter. It's the same as bumping into a car, or as Warren Buffett said one day, if an officer follows you for 500 miles, you're getting a ticket. When you send in hundreds of thousands of documents to the SEC, you're getting a ticket.
Yeah. I mean, that's a good analogy. And I think that's the reputational damage is also probably poorly understood by anyone who has not been through the process. So thank you for elaborating on that. I think we'll leave it there for now. So we've got this order from the commission directing the enforcement division to respond to the motion from a year plus ago. We'll see what happens, and maybe we'll follow up in 6 months and see where things stand. But in the meantime, Tom, thank you so much for coming on. Mark, thank you so much for co-hosting. For everyone else, we'll see you on the next SEC Roundup. And if you want more information about ICAN, go to icanlaw.org. Thank you. Bye-bye.
Mark, thank you.